Lordship. Item number 44 and 45, my Lord. I filed an additional affidavit today, my Lord. My Lord, this record may be closed, my Lord.
In this case, I'm for the respondents, so the copies will serve on after and today only. So let's go through it. So may I pray let the matter come?
Let it affidavit come and be tagged. We'll adjourn it.
Yes.
Renew the prayer when the matter is reached.
Let item 34 minute. If you take next week any date better. And for
34.
34.
Okay. After 2 weeks.
Fast. Right, please, your last.
34.
Fine. Right, please, your last. My lord, I pick to national item number 24, you lost. The next week, my can do it.
24. Okay. 2 weeks.
Oblige.
Item 7, my lord. We were supposed to file rejoinder. Because of the vacation, we could not file. 2 days, my lord. It will be listed next week, my lord. Next week.
This after a week. So as to enable the learned counsel for the petitioner to file a rejoinder affidavit.
I'm grateful, my lord.
Yeah, please, your lordship. So I beg to mention item number 10. It's a matter maybe come after 1 week, lordship. No, 10.
10. Answer matter. Okay. After the
Next week, any date, lordship.
okay.
Possibly.
Please, Your Lordship. My lord, I beg to mention item number 19, my lord. The brief is along with Mr. Aich Khan, my lord. He is out of station. Kindly adjourn the matter for that day.
Okay. After a week, explain for learned counsel for the petitioner. Okay.
Wait, item number 2, kindly adjourn the matter.
Item number 2.
Amnesty.
2, no. It's a 2019 matter.
19.
Just wait for some time. Let the matter be reached.
Next week.
Let the matter be reached. Make a unity prayer when the matter is called. Next.
Please, Your Lordship, which I beg to mention item number 5, Your Lordship. Only this matter come after 1 week, Your Lordship.
I wait till the matter is called. Let
Lordship.
the matter be called.
Regarding item number 32, Your Lordship.
Item
32.
32. Basi. 32.
Yes, Your Lordship.
Okay. List 32 after 2 weeks.
Oblige, Lordship.
Oh, after a week is a motion matter. Okay.
May I please, Your Lordship? So I beg to mention item number 6, Lordship. Kindly allow for 1 week, Lordship.
Okay, 6 after a week.
Oblige, Lordship.
Wait, is a lawsuit. Lordship, I beg to mention item number 25, Lordship. Lordship may not like to take up this matter, Lordship.
List after any other bench without one of us cares on Ajay. Okay.
Oblige, sir.
Supplementary item 47 for withdrawal.
Lordship, I beg to appear in this matter. Am I audible, Your Lordship?
Yes.
Your Lordship, I had on the last date that IA which they had filed for withdrawal was not served on me. They have served me this copy and I've taken instructions and we have no objections to the withdrawal of the writ appeal. And insofar as an IA 2125 of 2025 which we had filed is concerned, Your Lordship, that, my lord, I have instructions not to press that IA.
47. I. Upon instructions, Mr. D.P. Bora, learned counsel for the applicant, craves leave to allow the petitioners to withdraw the connected WA 244 of 2022. Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. N. Gautam. sorry, Mr. A. Chakravarti, comma, appearing for respondent number 1, as well as Mr.
A. Phukon.
Mr. A. Fukan, counsel for respondent number.
My lord, we were actually for the appellant, my lord, but there has been a change in the executive committee. So the new executive committee has taken over, and I was representing the erstwhile association through the earlier president.
Okay, Mr. A. Fukan, counsel for the connected IA civil 2125 of 2025. Have no objection. Stop accordingly. This interlocutory, the prayer made in this interlocutory application stands allowed, and the connected stands allowed. First of all, separate orders would be passed in the connected WA 244 of 2022 and IA civil 2125 of 2020. In these two matters, you say in rate appeal 244, you say Mr. D.P. Boral and counsel for the appellant, Mr. Same names, Mr. K. Chaudhary, along with Mr. A. Chakravarti for respondent number 1 and Mr. A. Fukan for the applicant in IA civil 2125 or 2025 are present. In view of order passed today in IA civil 2082 of 2025, this requisition stands dismissed from withdrawal. And
All connected IAs are also closed.
this is okay. I did not see you for the state, Mr. D. Mazumdar, an additional advocate general for the state, along with Mr. P. Nayak, additional advocate general for the state, are present. And in this IA 2125, Mr. A. Fukan, counsel for the applicant,
Does not wish to press.
does not wish to press this IA. Mr. Accordingly, this IA stands dismissed, having not been pressed.
Deeply obliged.
Deeply obliged, your lordship.
Yes, item 1.
Thank you, the lordship. In this case, lordship, writ petitioner died, so we have filed one IA for substitution. Your lordship already allowed substitution, and thereafter we have filed amended cost title also.
Okay.
As there is a mistake in IA district commissioner lordship, so we have filed amended cost title in IA also.
Okay.
But CIS system not yet updated, lordship. And your lordship has fixed this matter for motion, lordship, though it was recorded that this matter may be listed for admission, but not yet issued any notice, lordship.
Mrs. R. Chaudhary, learned counsel for the petitioner, submits that pursuant to order dated 30/5/2025, the cost title in respect of the deceased petitioner, as well as respondent number 3, i.e. the district commissioner, has been amended. Stop. She submits that the consequential amendment to CS has not been made. All the respondents are duly represented. Next paragraph, issue notice returnable. Give a date after 2 weeks. Returnable on so and so. No steps is required to be taken, as copies have been served on the learned state and departmental council. You have received copies?
Yes.
Next paragraph, list in the next paragraph, the registry shall make suitable corrections in the CIS system to incorporate the substituted petitioners as well as the respondent number 3. Next paragraph, list in the admission column on Swells.
1-8.
Right.
Item 2.
Right, Your Lordship. This matter was listed on 14/5/2020, and later on this matter was not listed. And as your was called for. Okay, we'll take it up next week. He's asking for an adjournment. Okay, let this turn next matter. Kindly allow for interim.
No.
If you move the matter on merit, we'll consider the interim prayer. List on 28/7/2025 as paid for by the council of the staff.
Item 3,
My lord, in this case, my lord, the LCR was called for.
This is exhibit E and F. What is exhibit E and F?
My lord, exhibit E, your lordship, my lord.
I am not exhibit E. You tell us
Now,
what is,
I'm explaining, my lord, what is exhibit A,
just tell us what is exhibit E and F.
E and F.
You are reading now. You take it up at 2 o'clock.
My lord, no, my lord,
We don't have
exhibit
time.
E is the school
We
certificate.
don't have time. Take it at 2 o'clock. Please be
School
prepared.
certificate, my lord.
At 2 o'clock.
My lord, exhibit E is the.
You see, we are spending
school
some time. We
certificate,
are
my lord.
asking you and then you are spending time. You are reading here and then trying to find out.
I'm not reading, my lord. I'm, my lord,
Two things
I
we
have
want.
find out
Exhibit E
the
and exhibit F.
exhibit E is the school certificate. Exhibit F is
Which
the
page?
Gaon Panchayat certificate.
Which page?
Page 95.
Which page is the opinion?
My lord, page 95 of the impugned opinion, my lord. It is stated the exhibit, list of exhibits your lordship will find.
Opinion is at page?
93.
Page 93, relevant page is, my lord, 95. And which has been, my lord, filed along with written statement, my lord. Page 49 and page 50.
Mr. Sen, then you don't have any document to connect you, make you as the citizen. This exhibit F, G, and H.
My lord.
Sorry, E, F, and G. If they got, then nothing remains in your case.
My lord, exhibit B, C, D.
They're on the voter list.
My lord, voter list, yes. And my lord, apart from E, F, G, my lord, there are, my lord, land documents, my lord, which we have annexed with this application, my lord. That is, patta of the land stands in the name of.
But those are
our
not
father.
exhibited documents.
But that was, my lord, not exhibited. That's correct, my lord.
Where is your first voter list?
First voter list, my lord. My lord, first 1951 NRC, then my lord 1966.
No, that is not your voter list.
My voter list, my lord. Hmm. 97, my lord,
97, which page?
page 35,
85,
35.
35. 35, you are not a voter. Your name is Morjina Begum. Morjina Begum is not a voter, is 1997. Mr. Sen, we appear to be more well versed in your documents than you.
Abdul Jalil is my father, my lord.
No, I am asking you, see, for the third time I'm asking you, where is your, where is the voter list where your name appears?
Page 44, my lord. Page 44, at the bottom, your lordship will find.
There is a date where you are testing our patience. Correct. Today is a date you are testing our patience. Was this document an exhibited document? Mr. Sen, you are aware of the number of cases listed today.
My lord.
You want to read it here? You don't
No,
don't do any homework at your home.
I did, my lord, but page 44 is the voter list, my lord. At page 44, I have shown. My lord.
Is it a exhibited voter list? Okay, we'll pass orders in chambers.
It was exhibited, my lord.
Then tell us. The simple thing we are asking you,
Yes,
and you are
it was.
testing our patience. Which is that exhibit?
It was not exhibited, my lord. It was not.
Okay, we'll pass orders in chambers. Next.
Item 4.
May it please, your lordship.
Yes.
My lord. This 37 is the
Opinion at page. Opinion at page
37.
37. Which is the best document you are having connected to your projected parents?
Page 55 to 58, your lordship. Jamabandi copy. Your lordship. And your lordship also.
Just a moment. Page number
Page number, your lordship. 56, your lordship.
50.
56, your lordship. Barney color.
This is not an exhibited document.
This is not exhibited, your lordship. Subsequently given, your lordship. So for consideration, your lordship. So exhibited document, your lordship, page 53 and 54, your lordship. So this document is a lordship consideration, your lordship, because I have the base document, but that time could not be produced, your lordship. Full certificate, your lordship. Page 53.
Just a moment.
The headmaster also examined you, sir.
Who is DW two?
Lordship. It is the elder brother, your lordship. Abdul Corpus.
Where is your evidence on affidavit?
Lordship.
Evidence on
Evidence on affidavit, your lordship, of DW two space 26, your lordship, and DW one is at your lordship, page 20, your lordship, 20 of the petitioner. And except two.
And the 1989 voter list?
1980, my name, lordship, for the first time, my name did appear, your lordship, in the 1989 voter list. Lordship is at page. Lordship.
You are in a different village.
Lordship, because that time, because of the Bodo agitation, your lordship, because our house, your lordship, burned down by that extremist. Your lordship.
That is not mentioned in your written statement.
But your lordship, here in the, it's mentioned, your lordship, can we see your lordship, page 18, your lordship, page 18.
18.
18, page 18, para number 10, your lordship. Para number 10, WS.
In the admission column next week,
Lordship.
is an order for you not to be deported.
Earlier orders, there is not to be deported, lordship. But your lordship, protection may kindly be given, your lordship. Bail may
There
kindly.
is in fact nothing in your matter.
Lordship,
No,
I will appear
there's-
before the
there's-
border. your
There's
lordship.
no
And,
connection.
Is your lordship also
Next week we are taking it up for hearing.
studied your lordship up to class 7 that time, your lordship. In the certificate is in the. So lordship, protection may kindly
That-
be given because this time
The
situation.
evidence of DW3 for you is very damaging.
Lordship, DW3, this is the headmaster, your lordship.
So damaging evidence. We have read that.
Lordship, kindly protect me, your lordship.
We'll take it up next week for admission. The
Because
interim
this,
production not to be
lo-
deported shall continue.
Lordship, TCR has come, your lordship.
Interim
TCR
production to not to be deported, that will
Because your
continue.
lordship, first listed on your lordship.
No, we understand, but we are not satisfied with any document you are having.
But
Perhaps-
lordship, there's the Jamandi copy of lordship acceptance and consideration, your lordship, although not.
Jamanti is not an exhibited document.
Not
We
exhibited,
consider on
your
that
lordship,
day.
Not exhibited, your lordship, but subsequently obtained, your lordship.
No,
That
it's
time
okay.
could not, because.
We'll consider
still
that.
not Also,
Which page is that, Jamanti?
Jamandi is that, because that time it was not convenient for me
No, it's
to.
okay. Where is
My
that?
lordship is 56, your lordship. Because along with the father, your lordship, the name of the petition is also there, your lordship. That is as, father is Bolomia, serial number 1, page 56, your lordship. Particular.
Just a minute.
And serial number 4, Umar Ali, the petitioner.
You see, even on consideration of your document, which was not exhibited,
Lordship,
we have seen that because it was of prior to 1971,
Yes.
this
Lordship.
prior to 25/3/1971. We have just seen that. But you see, how do you explain the evidence of DW2 and connect you to the same parents? Number one, if you come to page 43, the age difference between the mother and son is only 11 years.
Yes.
That means,
43, Lordship.
that means your elder brother was born when your mother was 11 years old. It's not reliable. And then your brother says, amongst others, the first brother's name is Sabur Mia. Sabur Mia is not of the family.
So Lordship is also conversant in the fact, Your Lordship. Thus, this age discrepancy, Your Lordship, it's a apparent, Your Lordship, in most of the voter list, Your Lordship.
No, that we don't know. We have no idea.
Because and most of the opinions also this pointed out this discrepancy, age differences are there. I'm not
No, we
denying,
don't know. We can't generalize.
Lordship.
In a given case, you can give evidence that it was a mistake, but
Lordship,
we don't
Lordship.
find that there was any evidence led to
Lordship.
explain that mistake.
So even then, Lordship, my prayer, Lordship, kindly give credence, Your Lordship, of DW2 and DW4, Your Lordship. Because the elder brother, because he is very, and fully corroborated, Your Lordship. Whatever I have stated in my written statement, you have fully corroborated. By
No,
the
written statement, you have not introduced your brother. His introduction is only in your evidence.
Because, Your Lordship, school certificate exhibited, Your Lordship. The aura has also been examined, is also reflected in the opinion, Your Lordship. And only thing is that, Your Lordship, one good document is there, Your Lordship, that document could not be produced. Because that point of time, I did not get sufficient opportunity to produce the document, Your Lordship. So, Lordship, my because ultimately, Your Lordship, on the eventually, Your Lordship, on the merit of the case, Your Lordship, I'm not on that, Your Lordship. But till then, Your Lordship, I may be protected. At the time of hearing, Your Lordship, that will go on merit, Your Lordship. And also, I'll try to satisfy Your Lordship with the acceptance, Your Lordship. I'll try.
No, sorry, we are not finding a connect. We will give you same protection.
My
We are
lord,
not giving you bail at this moment.
my lord. In page 56, lordship, in Montabbo column, lordship,
Yes.
lordship. ম্যাদী 649/70 নং দৰখাস্তৰ উপপ্ৰতি সমাহৰ্তাৰ 2/2/71 ইংৰাজী তাৰিখৰ হুকুম মতে এই পত্তাত প্ৰিমিয়াম আদায় ক্ৰমে শ্ৰী বলো মিয়াৰ নামত 1378 চনৰ বন্দোবস্তিত নতুন ম্যাদীভুক্ত কৰা হ'ল। ইটি স্বাক্ষৰ অস্পষ্ট টাং 25/1/71 because lordship here prior to order passed by the concerned official lordship, it was signed lordship. Was muted and as per order dated 2/2/71 and in below signature it was 25/1/1971.
So apparently there's some mistake in the entry.
Also, this is not an exhibited document lordship.
Oh, that's okay, but
No, everything. Nothing. Lordship. Lordship, page 30 may kindly be looked into for a while.
30.
30. Elder brother's statement, deposition, Your Lordship. My name is Abdul Quddus Mia. I am 84 years of old, Your Lordship. So, Your Lordship, what I beg to submit before Your Lordship is that I'm 85 years of age, Your Lordship, the person, elder brother, he has deposed, Your Lordship. Stating all the details, Your Lordship, about her siblings and all, Your Lordship. All the details you stated, Your Lordship.
That is the problem. That deposition itself makes us think again. Sobur Mahmud is nowhere there. Your written statement doesn't have the entire family together. Even in the evidence, your entire family is not there together.
It was the written statement, Your Lordship.
Your brother's evidence is better than yours. But he has added one more
Evidence.
family member who is not there. That makes us think twice for bail.
Next week. He is already in protection, Lordship, so Lordship
No,
may
no,
hardly
already
matter.
protection is not to be deported, Lordship,
We'll
because
pick it up next week.
I may be arrested at any time, sir.
We'll be taking up next week. We're not satisfied.
And situation is also not very good, Your Lordship.
Mr. A. Devata and Counsel for the petitioner. All the respondents are there. Pursuant to order dated 4/10/2024, the records of the tribunal is received. Accordingly, is the matter in the admission column on 30/7/2025. It's an interim protection granted by order dated 4/10/2024 stands extended till the next date of the state.
Lordship, date may kindly.
30/30/307.
Devolved.
Item 5. Yes.
Last occasion, my lord, we have submit one instruction, my lord. With the, now the person holding area of.
You have visited,
Yes, Your Lordship, and we have obtained signature in the protocol.
then this matter can be closed.
Yes, Your Lordship.
Your name?
M. Medhi, Lordship. M. Medhi.
M. Medhi. Heard Ms. M. Medhi, learned counsel for the petitioner. All the respondents are there. Next paragraph. On 25/5/2025, the police personnel from Komargaon police station had taken the taken Mrs. Arifa Begum, Afia Begum, into custody, and thereafter her whereabouts were not known, and therefore this habeas corpus petition was filed under Article 226 of the Constitution of India. Next paragraph. Pursuant to orders passed earlier, the learned standing counsel for the FT matters has produced instructions which is recorded in order dated 23/6/2025 to the effect that the daughter of the petitioner Afia Begum was declared to be a foreign national wide opinion dated 6/11/2015, passed in FTG, capital FTG, within bracket D, bracket close 96/2007. Most of the said opinion has been assailed before this court by filing WPC 4779 of 2016 which was dismissed by order dated 21/8/2018. Full stop. Accordingly, next, but according to this court had granted the petitioner with two other family members two other persons visitation right to the detained person, namely Afia Begum at the holding center under 7th Assam Police Battalion, Soraikhola, Kokrajhar. Next para, the learned counsel for the petitioner, upon instructions, has submitted that the petitioner has met the detained person and has obtained the signature in the Wakalatnama. Next para. Accordingly, as the detained person has been taken into custody in the strength of opinion passed by the learned member, Foreigners Tribunal, Jorhat, as referred above. And as the petitioner has been able to meet the detained person at the holding center, the court is of the considered opinion that the purpose of this habeas corpus petition has been achieved. First of all, accordingly, without prejudice to any right that the petitioner may have, the petitioner or the detained person may have in respect of the opinion referred above, this habeas corpus petition stands closed.
Item 8.
Yes,
Page 83, that's all.
page
83.
83. The challenging 2023 opinion.
Yes.
Okay, you'll have to wait for some time for bail. You'll not be deported out of the country.
Yes.
Mr.
M.A. Mondal.
M.A. Mandal, and counsel for the petitioner. Opinion is at page 83. Dated 14/12/2023. Notice returnable on, leave a date after 4 weeks.
1st of August.
No, first of all, give it 4 weeks. Because it will go usual process. I might take 4 weeks. In 18/8, 18/8/2025. Extra copies in course of the day. The relevant records be requisitioned from the concerned tribunal by usual process as well as by email and the following email address of the learned tribunal. Next paragraph. The prayer for bail shall be considered on receipt of tribunal's records. Next paragraph. In the meanwhile, if the petitioner, namely Nur Jamal Sheikh SK, is apprehended, he shall not be deported out of the country without order of the court. Next paragraph. The petitioner shall produce a certified copy of the order before the senior superintendent of police within bracket. No, not to be deputy commissioner, deputy commissioner of police, deputy commissioner of police within bracket border, Kamrup Metro, Guwahati. No, you'll have to amend your 4 and 5, you'll have to amend. You have Superintendent of Police Border or it will be Deputy Commissioner of,
DCP border, Kamrup Metro.
huh?
For Kamrup Metro Lordship, DCP border.
SP Border
DCP.
or DCP Border, huh?
Yes.
That's right. 4 and 5, you'll have to amend. Next one is
Yes.
the nomenclature of respondent before I, the Deputy Commissioner, Kamrup Metro, as well as Superintendent of Police Border, Kamrup Metro do not exist, comma, the petitioner, the land council with the petitioner shall file a amended copy of the cost title before the AOJ FT section, so as to incorporate it in the writ petition and to make consequential amendment in the central registry. Action course within 2 days. The issuance of certified copy shall be delayed till the cost title is amended. Next, list on so and so.
Item 9.
Input order page 55.
Page
55.
55. Mr.
M. Hawk.
M. Hawk, Internal Counsel for the petitioner. All the respondents are there. Page 55, impugn opinion dated 29/1/2025. Notice returnable in 4 weeks. Extra copies within 2 days. Call for the relevant records. The prayer for bail is opposed by the learned standing counsel for the FT matters. So bail of is 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border,
Dualpara.
Gwalpara. List on so and so.
Published.
Item 11.
Yes, open at page
9-8. Opinion, please.
9/8. '21. So you have to wait for some time for bail. But Mr.
S. Hussain.
S. Hussain, learned constable petitioner, respondents are there. Opening at page 98, dated 22/2/2021, passed by so and so in FT case number so and so, reference case number so and so. Declaring the petition to be a foreign of post 98 civil streamed. Notice returnable on 18/8. Extra copies within 2 days. Call for the relevant records from the concerned tribunal. The prayer for bail shall be considered on receipt of the records of the tribunal. Next, in the meanwhile, if the petitioner, namely Nur Islam, alias Nurul Islam, is apprehended, he shall not be deported out of the country without order of the court. Next one. Petitioners have produced a certified copy of the order before the Superintendent of Police Border. Which place?
Nogam.
Nogam. To bring the order to the notice of the said authority. List on 18.8.
12.
Yes, opening that page.
Order at page 73, Lordship. And date of order is 15/3/2021.
73,
73, yes.
21. Okay, same order. Mr.
Yeah, Ali.
A. Ali, Learned Counsel for the petitioner. Page 73, 15/3/2021, passed by so-and-so in case number so-and-so, FT case number so-and-so. Same order. This is SP border,
Borpeta, Lordship.
Borpeta. Not to be deported.
Okay.
13.
Yes, opening that page,
My lord, page number 17, my lord.
17,
My lord. 19/4/2021.
21. You wait for some time for bail.
My lord.
Mr. A.W. Aman, Learned Counsel for the petitioner. Same order, page 17. Opinion dated 19/4/2021, passed by so-and-so in so-and-so, so-and-so. If bail shall be considered on this reports, not to be deported. The petitioners have produced a certified copy of the order before the Superintendent of Police border,
Kamrup.
Kamrup. Okay.
Fourteen.
Page 26, my lord. It's 29/6/2024, but we have filed before that, my lord. Filed on 25/6, my lord. Within a year. Just within a year.
Okay. You succeed to convince us.
My lord.
Mr. A.W. Aman, Learned Counsel for the petitioner. Respondents are there. This page 26, opinion dated 29/6/2024, passed by so-and-so. In case number so-and-so, SP reference number so-and-so. Declaring the petitioner to be a foreigner post 25/3/1971 stream. She's a lady. Notice returnable on in 4 weeks, extra copies within 2 days. Relevant records be requisitioned from the consent tribunal. Therefore, bail is opposed by the learned standing counsel for the FT matters, considering the projection made in this petition. 10 days time to take bail of ₹5,000 to the satisfaction of SP
Nalbari.
border,
SP border Nalbari.
Nalbari. Okay,
Grateful, my lord.
list after 4 weeks.
15.
Yes,
May I please, Your Lordship?
opinion at page.
To not arrest, page number 85.
85, you have to wait for some time for bail. But Mr. H. A. Ahmed, Learned Counsel for the petitioner. All the respondents are there. Page 85, opinion dated 27/3/2024, passed by so-and-so in FT case number so-and-so. IMDT case number, so and so. We're declaring the petitioner to be a foreigner of post 25 through 1971 stream. Notice returnable on 18/8/2025. Extra copies within 2 days. Call for the relevant records from the concerned tribunal by usual process as well as by email at the following email address of the learned tribunal. Next one, the prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely so and so, is Jamiluddin alias Jamil Ali. He is a printer, it shall not be deported out of the country without order of the court. Petitioners have produced a certified copy of this order before the SP border. Which place? Bojali. Okay. List on 18/8.
My lord, one prayer, my lord, respondent number 5, I may be allowed to amend this petition, deputy commissioner in this
Number 5, you want to?
amend, my lord.
Okay. Learned counsel of the petitioner pays to allow him to amend the cost title in respect of respondent number 5, I, the deputy commissioner, Bojali, the officer of correct description, there is allowed. The learned counsel of the petitioner shall provide a type copy of the cost title to the AOJ FT section to bring to be incorporated in the petition with constitutional amendment to the central registry. So the issuance of certified copy of the order shall be delayed till the correction is made. Your certified copy will be delayed till you correct it.
Item 16.
The Indian opinion is at page 63.
Page
63.
Okay. But Mr.
Yes, Ahmed.
S. Ahmed, learned counsel for the petitioner. Page 63, opinion dated 26/4/2022. Passed by so and so in FT case number so and so, SP border reference number so and so. They were declaring the petitioner to be a foreigner post 25 through 1971 stream. Notice returnable on 18/8. Extra copies within 2 days. Call for the relevant records from the concerned tribunal. Therefore, bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely Anufa Khatun, is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioners have produced a certified copy of the order before the Superintendent of Police border.
No.
Now want to bring the order to the notice of the said authority. Okay. List on 18/8.
17.
Yes,
Yes, may I please your lordship? Lordship,
Opinion dated?
This is contested matter and opinion dated is 12/8/2024.
page.
Page 31, lordship.
Okay. Heard Mr. S. Chakman and
A.K. Haz-
A.K. Hajong, I'm sorry. A.K. Hajong, and counsel for the petitioner. The respondents are there. Page 31, opinion dated 12/8/2024. Passed by so-and-so in FT case number so-and-so, police reference case number so-and-so. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies within 2 days. Call for the records. Prayer for bail is opposed by the Royal Standing Counsel for the FT matters, considering the position made in the writ petition. 10 days time to take bail of rupees 5,000 to the satisfaction of SP Border, Dhobri. List after 4 weeks.
18,
Negative lordship. So 110 lordship is the opinion lordship. Lordship, although the opinion dated is 18/12/2023. Lordship, I got it in the month of lordship, September 2024 lordship. There's some delay to pass the order lordship, that's sorry.
Okay, you still have to wait for some time for bail.
Lordship, I explained in my petition lordship, page, paragraph 25 page. Lordship,
I had 25.
25 lordship, page 32.
But you have not given the date when the hearing was concluded.
Lordship, hearing actual one date I could not lordship. There are two date lordship is the argument of some.
But we don't know the date.
Yes,
So
that's
what
right.
is so difficult to give a date?
Now, lordship, actually, after that lordship, I have also called with my learned advocate. That's why lordship, he also given not that exact date lordship. Therefore, lordship, when I have to engage another advocate lordship to check the record lordship. The party came to us lordship without substituting document lordship. Because he is quarrel with the learned council.
No, but you see,
Two advocates have engaged lordship.
no, we understand. We are not saying, we are not denying you what you are saying.
Lordship,
But if you don't give the date, how can we make up our mind?
lordship. Lordship, always become lordship, especially 1 month lordship prior lordship. Argument thereafter lordship, given for opinion lordship. It's approximately 1 month back lordship.
You have to wait for some time unless you give the date. But Mr. S. Hawk, Learned Counsel for the petitioner. The respondents are there. Page 110, opinion dated 18/12/2023, passed by so-and-so in FT case number so-and-so, corresponding to R case number so-and-so. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable on 18/8. Extra copies within 2 days. Call for the relevant records from the concerned tribunal by usual process as well as by email at the following email address of the tribunal. Prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner named Mainul Haq is apprehended, he shall not be deported out of the country without order of the court. Before that, you also write, as the nomenclature of respondent number 5 does not exist, the counsel of the petitioner shall amend the cause title in respect of respondent number 4. While submitting a freshly typed out cause title to the AOJ FT section to be incorporated in the petition and for constitution amendment in the central registry. Next. Shall be done within 2 days, huh? The issuance of certified copy shall be delayed till the cost title is amended. Next list on 18/8/2025.
Item 20.
Lordship, in order is at page 85, ma'am.
Your name?
M. Ali.
Mr. M. Ali, Land Counsel for the petitioner. All the respondents are there. Page 85. Opinion dated 28/3/2025. Passed by so-and-so in case number so-and-so. Reference case number so-and-so. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks. Extra copies, call for records. 10 days time to take bail of ₹5,000 to the satisfaction of
SP Border Gwalpara
SP Border Gwalpara.
of life.
21.
Opinion at page.
Lordship,
Yes.
Lordship, I am a permanent resident of the Walpara district. I have never visited Silchar, and I have never been subjected to any inquiry conducted by the Border Police of Silchar. Recently, I have received a notice issued by the Foreigners Tribunal of Silchar requiring to prove my citizenship. Lordship, this and notice is sent along with the information report of the suspected foreign nationals, and this information report is not pertains to me. The age, address, name, everything is different. My humble submission is that the reference is made without conducting any inquiry, without verifying any document. Lordship will find even then the case number is not there in the notice also. Lordship will find the notice is on the page number 11 and the information reporting page number 13.
Sir Sharma, please find out. Please find out. He's trying to say by referring to page 12, he has received a notice.
Lordship.
And then page 14 is the interrogation report. Let's have some lady.
Lordship.
Just find out what has happened. We'll take it up after 10 days.
One more thing, Lordship, if I am not wrong, probably there is no case number in the notice also.
Hmm?
The notice, there is no case number also, FT case number, one memo number is there, but it is sent without mentioning the case number.
This is a photocopy, we can't read. You have a original copy?
Original copy, presently I don't have, Lordship, but I can produce.
Show it to Mr. Sharma, he will be able to identify. This is the case number is there.
Yes, Lordship. May
Same. FT6 SLC CR 2020 to same, It's the memo number also. Same,
We don't know.
same number is repeated down below as a memo number.
This is the case number.
Yes, Lordship.
This will be the case number.
222 of 2025.
222 of 2025.
Yes. This Lordship. Interrogation report is also not legible, Lordship.
So that's why we are asking to get it and show it to you. Whatever
Type
it is,
copy-
but it is in the column number 6. I can't read, 6 or 8. Profession is housewife. So it is a lady.
Lordship. Lordship may kindly call for the record, Lordship.
You can get it through you.
Lordship.
It will be faster.
In the middle, Lordship, the proceeding kindly may be stayed, Lordship.
We are calling for the records. There's no question of any
Lordship.
proceeding. Heard. Mr. F.Z. Mazumdar, Learned Counsel for the petitioner. All the respondents are there. You will get the slip. Next one. By referring to Annexure B to the writ petition, might is submitted that the same is respect of a lady against whom an inquiry was made. Mr. However, notice has been issued to the petitioner for his appearance in the proceedings before the Foreigners Tribunal, 6th, Kachar, Silchar. Next one. Let the records of FT, page 11, FT oblique 6th oblique SLCR oblique 222 oblique 2025. The requisition and produced by the concerned officials of the Home and Political within bracket B department. So accordingly, the learned standing counsel for the FT matters shall communicate a download copy of this order to the superintendent of, to the Home and Political within bracket B department, so as to enable the said authorities to concerned authorities to requisition the records and to produce before the court. Next, in the meanwhile, if any date for appearance is fixed before the Relevant Tribunal, the petitioner is granted liberty to pray for an adjournment, producing a certified copy of this order. And accordingly, the said Relevant Tribunal shall defer the proceedings till the next date of listing. Next para, list on when
2 weeks, Lordship.
okay. We make it 4th of August, 4/8/2025. Take a short break and come back.
Page 45, my lord. By this order, my lord, I may declare as a OP is not declare not to be an illegal migrant. And by the impugn order, my lord, I may declare as a foreigner.
Then record may also be called for. Sorry. Nine. লাগিলে মই কৰি ল'ম।
Why in this case, res judicata would not apply?
Lordship.
Why in this case, principle of res judicata would not apply? Page 45 is the tribunal's opinion, IMDT. You see these records,
Yes, sir.
but that record has not come. IMDT records have not come.
Yes, Lordship. Let that records may also come, Lordship.
But here past orders,
Page 45, Lordship.
that records have not come.
Yes, Lord.
We in fact gave bail to the petitioner. The notice was served to the tribunal by email as well as by usual process, but the records have not been sent. They have not even informed the court as to whether the records are available or not. In view of the earlier opinion, we are giving bail to the petitioner.
Lord.
And even without referring to that opinion, please come to the, you have the records.
Yes, Lord.
There is a voter list which is in, yes, this one. In 65 voter list, his name is there,
Yes.
correct? Few pages before that, you will find his cross-examination. You've seen the cross-examination?
Yes, Lord.
Correct. Now, please come to page, page 68.
Of the repetition.
Of the petition. Second paragraph. This is the part of the opinion.
Yes, Lord.
Now he has discarded this 1964. Why his elder brother's whereabouts has not disclosed later on?
Lordship.
Can that be a ground to discard a voter list whose name is there in 1965?
No. No.
His name is there. It's not. He's not linking his name with somebody's whose name appears in 1965 voter list. His own name is there. Now that was discarded. You see, there's in this opinion, there's no reference to Exhibit F. In the previous page, page 67,
Yes, Lordship.
fourth paragraph, he makes a general assessment.
Lordship.
And he says that the last 5 lines, further nature and character of reference has also undergone substantial change following declaration of the IMDT Act as unconstitutional. Now the present reference burden is on the proceeding to prove is not a so and so. So he has produced
Yes, Lord.
the opinion. He has produced a certified copy of the voter list of 1965.
Kindly give me 1 day or 2 days time, Lord. Actually, I don't have the copy, Lordship. I want to go through the petition afresh, Lordship. And then I will make my submission. Otherwise, Lordship, this is not correct, Lordship.
We take it up tomorrow.
Tomorrow, day after tomorrow, Lordship, I have to reconstruct the copy, Lord.
Okay, give a copy to him.
Okay.
We take it up day after tomorrow. We will give you a copy. Mr. Mehdi, please give him a copy.
Yes, my lord.
All sides are represented. The records of IMDT case number 413 of 1990, for which requisition has been served on the Foreigners Tribunal number first, Dorang, Mongolde, has not been received. Next paragraph. The runner standing, Mr. G. Sharma, runner standing counsel for the FT matters, has prayed for a copy of the writ petition. So, the runner counsel for the petition shall provide a copy of the writ petition to the runner standing counsel for the FT matters. You want to give this record also?
Lord.
Next paragraph. The learned standing counsel for the FT matters is also has prayed for and is granted custody of the records of FT within bracket 2, bracket close, case number 388 of 2007, which is received from the Foreigners Tribunal number 2nd, Darang, Mangalday. To enable him to peruse the same and address the court. Next paragraph. List on. Day after tomorrow, 16. Okay.
Must.
Record to the
Item 35 for admission.
Yes, Mr. Goswami.
LCR has received, Lordship. LCR has received, and
What is the best document you have to connect you to your
Lordship,
projected
the
parents?
address name is Faluk Khan, and Faluk Khan voter list of 1970 has been annexed as Annexure B,
Age
space 56 of the LCR,
56
of the LCR.
of the LCR.
Next page, Lordship will find the name of the father, Faluk Khan.
Page number
Page 56, Lordship.
66.
56. 56
Of the LCR.
LCR.
No, if LCR is, this is a part of affidavit of DW2.
Lordship. Part of the DW2. Page 56, Lordship.
Okay, parents name Faluk Khan. Okay, where is the voter list of 1970?
1970 voter list, Lordship will find at page 41. That is 66 voter list.
41 of the writ petition.
No, LCR. Lordship.
41.
And I have collected the legacy data that was not true before the ward court. Legacy data also collected subsequently. Legacy data also did not address name. I have annexed the writ petition.
And apart from voter list, what is the document to show your father's name?
Lordship will find the legacy data. Lordship will find at page.
No, not
58.
legacy data. Any other document except voter list? It shows your father's connection with you.
page 58 of the petition, Lordship.
58 of the writ petition. No, not NRC or not this voter list. Any other document to show your father's name?
Lordship will find a land documents, Lordship will find at page 97.
97.
Lordship will find at serial number 10, Palukha.
Okay, then we okay, then we are granting bail, Mr.
Lord,
Sharma.
Lord, sir.
Okay. Good. Mr. S.K. Goswami and counsel for the petitioner. All the respondents are there. Next, pursuant to order dated 12/2/2024, the records of the tribunal. Pursuant to order dated 8/1/2025 and 12/2/2024, the records of the. No, something is wrong. It will- Yes. 24. And ordered to 8/1/2025 and 12/2/2025, for the records of the tribunal is received. Next, where is the same? Next, court is inclined to issue notice returnable. Oh, notice is already issued. Where is the same? Next paragraph. Having regard to the nature of evidence which has been which is available on record, the court is inclined to grant bail to the petitioner, namely so and so. 10 days time to take bail of rupees 5,000 to the satisfaction of SP border. Bopita. Next, as the tribunal records are received, matter may be listed for hearing in the month of in the week commencing 18/8/2025. So next paragraph. It is observed that a typographical error has crept in the order dated 12/2/2025, as the date of the order is recorded as 12/2/2025, 24. So accordingly, the order dated 12/2/2024 shall be read as order dated 12/2/2025. Next paragraph. List the matter for hearing the week commencing 18/8/2025.
Public.
Next. So before that, you'll say those conditions are there for bail, huh? Those conditions. 10 days time to take bail.
Right.
You continue post lunch. We may be 5 minutes late in assembling again.
Item 36.
Regarding item 27, both of the records are lying at Tribunal. So, posting में आपको थोड़ी SP border to be, they will do the issue lot.
26.
Item 27. Whether it is custom or to be lottery, yes, that's sure.
Ah, yes, okay, it will be Dhuri.
Not to be loaded. And most of the records are lying at to be loaded. So in proceeding the approach before it to be, SP border to be, they will do the needful.
Okay. Rather make it alternative. If the records are at, if the records are at Dhubri, then Dhubri. If the records are at South Salma Mankachar, then Mankachar. Okay,
Approach to Dhubri, madam.
we are giving both options, otherwise it will come for correction again.
Ali Obles.
36.
My lord, in this case, record was called for and interim to the extent of not to
We
deport.
were also to hear you on the issue of delay and latches. 2018 opinion you are challenging.
Yes, my lord, 18. My lord, here, my lord, parents are voter in 1966, 70. And he is also voter in 1985 with her mother. He has two mother. Biological mother is Bibijan and stepmother.
Hearing the lottery. Lottery pieces from a hearing the lottery. Maybe got very also on delay and better. Regarding
Okay.
the proof.
It's okay, you want an adjournment today.
Lottery. Lottery method, then I have nothing to.
No, it's not that, because in this bench, I am ready for hearing at every time. If you want to take it up today, we are ready. If you want to, if you are praying for an adjourn, we will adjourn it.
Then adjourn the method.
Adjourn it. Okay. Take it up on Thursday? Okay.
My lord, in the next week, my lord.
Next
Some problem, my lord.
Tuesday next?
Yes, my lord.
Okay. Both sides. are
Till then, my
present.
lord, interim, my lord, whatever granted may be continued.
Okay. Both sides are represented. On the prayer made by Mr. G. Sharma, understanding also for the empty matters. The matters adjourned today, list on 22/7/2025. Okay.
Interim may continue, my lord.
Okay, interim order passed earlier, stands extended till the next date of list.
Item 37 for orders.
Please, your lordship. My lord, Mr. Shishi Dutta Senior Counsel is out of station, my lord. Since matter is 2013 also, we have to take instruction from our client.
To take instructions because we have the copy of order of Civil Appeal 5807 of 2017. The contempt will not survive. Okay. Miss
S. Musahari.
S. Musari, counsel for the petitioner, prays for an adjournment as she awaits updated instructions in the matter. Next one. We take notice of the fact that by a judgment and order dated 15/5/2025 passed by the Supreme Court of India in Civil Appeal number 5807/2017 dash Nagaland Public Service Commission within bracket through its chairman bracket closed and another versus Srimati Srimati Uholi PHUHOLI Holy Sema and others directions have been certain directions have been passed. Full stop. Next part accordingly. The matters are adjourned today to enable the learned counsel for the petitioner to obtain instructions as to whether any live issue survives in this contempt petition in light of the hearing before referred judgment and order dated 15/5/2025. Next para, list after 2 weeks.
Obliged.
Item 38 for orders.
Met, Your Lordship.
Yes, we don't find a ground even to issue a notice in this condemnation application.
Lordship, delays there. Delays there, put the condemnation.
That's why we don't even find a good case for even issuing a notice on the condemnation application. There's no explanation at all.
Yes, only financial problem, therefore he could come later.
This financial problem is something even a sound person may have it. We have insolvency act which deals with corporates who become bankrupt. We have bankruptcy act. We have so many things. So this term that not financially sound is too vague. কি করেছে? Sorry, we are dismissing this interrogatory application. We are not convinced even for issuance of notice. Heard Mr. A. Ali, Learned Counsel, appearing on behalf of Mr. N. Islam, Learned Counsel for the applicant on record. Next para. By filing this interlocutory application under Section 5 of the Limitation Act, comma, the applicant has prayed for condoning a delay of 2792 days beyond the period of limitation in filing the connected review petition preferred against the order dated 31/7/2017 passed by the division bench of this court in WA 93/2016. Next para. From the materials available on record, it appears that an ex parte opinion dated 8/10/2009 was passed by the Foreigners Tribunal number 1st, Borpeta, in FT case number 112/2006 within bracket capital B. Full stop. The petitioner had assailed the said ex parte opinion before this court by filing WPC 1402 of 2012. Full stop. However, comma, the learned single judge of this court, comma, by order dated 2/9/2015, comma, had dismissed the said writ petition. Full stop. The said order dated 2/9/2015 was assailed by the petitioner by filing an intra-court appeal which was registered as WA 93 of 2016. Full stop. The division bench of this court by order dated 31/7/2017, comma, dismissed the said appeal, intra-court appeal. Next para. The in this interlocutory application, comma, the two grounds on which the delay is sought to be condoned is that the applicant hails from a very remote village. And the second ground is that the petitioner is not financially sound. First of all, for these two reasons, comma, it is projected that the petitioner, that the applicant could not file the review petition in due time. Next para. Both the grounds both the grounds as projected in this interlocutory application are too vague. Full stop. The applicant has knowledge that by the opinion dated 31/7/2017, passed by the learned Foreigners Tribunal, number 1 Borpeta, comma, he was declared to be a foreigner. And the said ex parte opinion was unsuccessfully challenged by filing a writ petition. And thereafter, WA 93 of 2016. Full stop. It is not the case of the applicant that the order dated. No, that ex parte opinion is 8/10/2009, not 31/7. It will be 8/10/2009. Because it's not the case of the applicant that the order dated 31/7/2017 passed in WA 93 of 2016 was not communicated to the applicant. Full stop. Full stop. Therefore, comma, having stepped over the alleged right, comma, if any, of the applicant for 2792 days from the date when from 31/7/2017 when WA 93 of 2016 was dismissed, comma, the explanation for explaining the delay is not found to be acceptable or justified. Full stop. Rather, comma, this explanation is meritless. Next, accordingly, next para, it may be stated that the Learned Standing Counsel for the FT matters has also opposed the admission of issuance of notice in this application. Next para, be that as it may, as this explanation tendered for the delay is not found acceptable or of any merit, comma, this application stands dismissed. Next para. Consequently, the unnumbered review petition filed by
Lordship, review petition number 5.26/20.
Hmm?
Filing number. Filing review petition long is 5.26/25.
Oh, well, filing number review dot TT. Yeah, this is the slip. This one, huh? Back page. Review dot TET dot oblique 5126/2025. File on 25/4/2025. Also stands dismissed.
Item 39, for orders.
Yes, your Lordship. Lordship, I'd like to withdraw this petition. Lordship,
Yes.
Lordship, I would like to withdraw this petition with the liberty to file a fresh IA.
You want to withdraw this application?
Yes, your Lordship. Lordship, because the grounds mentioned in page 3 of the IA are not sufficient grounds, and I would like to file fresh IA with sufficient grounds and supporting documents.
Upon instructions, Miss
A. Hussain, Lordship. A. Hussain.
A. Hussain, counsel for the applicant, seeks to withdraw this application with leave to with liberty to approach again. Prayer is next panel. All the respondents are represented. And the prayer is allowed.
Much obliged.
This interlocutory application and the connected review petition. So unnumbered review petition bearing filing number review.pet./6752/2025. Filed on 30/5/2025. So stands dismissed on withdrawal with liberty as paid for. Yes, item 40.
Item 40.
Yes.
May please, your Lordship. My lord, here in this case, and a peculiar situation, the present IA has been filed. My lord, at the time of filing of the review petition, she was in custody. Subsequently, my lord, in the light of the Supreme Court decision, Supreme Court order, he was released on bail. And this court also subsequently granted bail. And he has been all along attending the, my lord, police, my lord. And he last attended on 22nd May 2025. And according to my lord, his regular attending dates, he was attending bi-weekly, my lord. So he is to appear before the police on 7/6/2025. Before
But now
that,
you will not be entitled to bail. But now you will not be entitled to bail because you must be deported. If what has happened to your review petition?
review petition is pending. My lord,
So
I was attending and
we
the
hear your
police
review
has
application.
police suddenly, my lord, before the date, my lord, stipulated date, call me and search my house. My lord, therefore, my lord, I have stopped to appear before the police, my lord. So my prayer is that, as usual, my lord, as earlier as attending, I will attend and I may be given a fresh bail. That is my prayer in this IL.
No,
I will
but we-
appear, but police suddenly, although I am attending regularly, bi-weekly, but police before the date comes, my lord, search my house and calling me to attend, my lord.
We'll take
Therefore,
up-
I am apprehending,
we'll-
my lord, and I have
We'll take
stopped
up
to
your
appear,
review petition for hearing.
my lord. Review petition may be hard, my lord. A date may be fixed, my lord. But I may be, my apprehension is that if I appear before the police may detain me.
No, for that we'll have to get instructions as to when you were appearing.
My lord, yes, my lord. I have annexed some of the copies of the attendance, my lord. My lord, initially I was attending weekly, and the lastly, my lord, I attended on 22nd May. My lord, is the annexer at page 10 to 13 may kindly have a look at, my lord. উঠাই লোৱা নাই, মানে ডেট অহাৰ আগতে মোক মাতিছিল সাৰ্চ কৰিছে সেইকাৰণে ভাবিছোঁ যে মোৰ
You obtain instructions, we'll take it up day after tomorrow about the attendance of the petitioner before the police station.
I have all the copies of the attendance sheets, my lord. But I have NS only 4, 5.
No, this 4-5 will not do.
My lord. Yes, I'll sharp copy. Photocopy lage to?
You give a photocopy of this, this interrogatory application.
Yes, my lord, I'll give.
Mr. A.R. Sigdal, and counsel for the applicant, shall provide a copy of this interrogatory application to Mr. G. Sharma, and standing counsel for the FD matters, to obtain instructions as to whether the applicant had been appearing before the concerned border police in terms of order dated 17/11/2022, passed in review petition number 54 of 2021. No, something is wrong.
My lord.
You're not on bail with, in terms of the High Court order of 17/11.
My lord, I was attending in terms of I was released on bail in terms of Supreme Court order. Subsequently, this order was also produced before the police. Police did not look it, my lord. And I was allowed to continue
No,
attending.
that's the difficulty.
I was attending, my lord. Bail was granted by this
No,
court
you have
on
to show us that.
17/11.
You have to show us that you executed the bail bond.
My lord, if the police did not do it, my lord, what I can do? I was attending even after this order. A copy we have served. Copy I have shown, but the police here told me that
No,
yes, he go on attending.
No.
But I am attending, my lord.
Would obtain instruction as to whether the petitioner, whether the applicant, namely Harej Ali alias Harej, had executed a bail bond in terms of order dated 17/11/2022, passed by this court in review petition number 54 of 2021. It number 1 of semicolon, and number 2, whether the petitioner, whether the applicant above named had been allowed to go on bail pursuant to page 8. Part 2. Site line. Next part. The learned standing counsel for the FT matters shall send a downloaded copy of this order to the concerned authorities in the Home and Political within bracket B bracket code department in order to obtain information. This will be which police station?
My lord, it will be, my lord.
Gograpar, to get information from the in charge of Gograpar police station. From the in charge border, in charge I in charge border, comma, Gograpar Police Station, District Nalbari. List on 16 7/2025. Okay. On that day, we'll fix a date for hearing of this review petition.
Item 41 for orders.
41, my lord, here, my lord, we have filed a review in 2021. And that review petition we are to withdraw because there are some formal defect in the filing, my lord. And this whole court by order dated 16/5/2024, Lordship will find the order at page 9 of the IA for condoning the delay. This whole court has granted liberty to file review petition. The paragraph 7 and 9, my lord, is relevant. Order to follow. So, my lord, immediately after withdrawal, we have filed the review petition.
No. Here, this review petition, this order was passed on 16/5/2024.
Yes, my lord.
You have come after a year.
My lord, we have filed, my lord. We have filed immediately after the withdrawal, my lord.
No.
There were some defects in the filing. We cleared the defects, my lord, later on. Defects were unnoticed. That is, there may be some. We have filed it on immediately after, my lord.
No, that will not do. A defective filing will not.
My lord, defects were unnoticed to us, my lord, and subsequently we have cleared the defects, my lord. And I'll do condone the delay. And IA has been filed praying for condoning the delay, my lord. My lord, we have to take 3 times, my lord. 3 steps have been taken in 3 occasions to remove the defects, my lord. One defect is cleared, then again another defect, then another. That's why, my lord, there was a delay in clearing the defects, and the delay has been in the listing, my lord.
No, we'll ask the registry to inquire in the administrative side. We'll place it before the Honorable the Chief Justice. But this can't be tolerated. For 1 year, a defect cannot be remained. If it is being done, we'll have an inquiry made and taken up next week.
Those defects were unnoticed to us, my lord. That is the problem, my lord.
It can't. If it is happening, then the registry will have to give an explanation why this has happened. You can't tolerate this. All sides are duly represented. Next, it is noticed that this interlocutory application under Section 5 of the Limitation Act has been filed on 22/5/2024, which appears from the seal of the filing assistant at page 1 of this review petition, of this interlocutory application, full stop. However, from the filing slip, it appears that there were several defects and this matter this matter was reported on 20 June 2025, which appears from the reporting seal of the filing assistant. Next para. Therefore, the court is inclined to send this matter to be placed before the Honorable the Chief Justice to look into the matter, to not be placed before the Honorable Chief Justice as the filing section is found to have withheld defective filing for more than a year. So that appropriate directions can be given to the registry. Just list the matter immediately after the matter is placed before the Honorable, placed and examined, placed before the Honorable the Chief Justice. If it doesn't come, you make a mention next Monday.
My lord.
Forty-two for orders.
Deep lovely.
This is an application praying for extension of time frame for appearing before the Superintendent of Police Board, Your Lordship. The order is at page 12.
There will be some change in the order and the last order. You just rewrite the order. It will be placed before the Registrar Judicial to examine the matter, and thereafter, if required, the same can be placed before the Honorable the Chief Justice to bring the matter to the notice of the to his kind notice. Yes, Mr. Datta.
So this is an application for extension of time for appearance before the Superintendent of Police Board of Morrigan, Lordship. The order is at page 12 with the starts from.
It's a 2023 order.
This December 2023, Lord. November 2023.
But what is the explanation for not taking bail despite the order of the court?
Explanation is that he went to Kerala, Lordship, for earning livelihood along with his son. And there his son made an accident. Ultimately, he expired there. So in between, he has no communication. Because I have annexed even the certificate issued by the police station regarding page 16 is the certificate. Both father and son work there. One newspaper publication.
No, Mr. Datta, we don't find this explanation a good explanation.
From paragraph.
This is an order of 24/11/23.
Yes, sir.
From 11/24 to 23, you have no explanation.
Lordship, I have explained it is from paragraph 5 to 9, Lordship.
This can't be a good explanation. Your mobile got damaged. SIM card stopped appearing, stopped working. Counsel could not be communicated. then you came to to your hometown for Eid, then you can't meet your advocate. The unfortunate accident of your son occurred in August 2024.
24. Thereafter, he came back.
Sorry, we can expedite the hearing where we are not inclined to grant bail.
That's it.
Extension of the bail order we are not inclined to give. So 2023 matter, we take it up for hearing on next Thursday over. Take it up for hearing on Thursday. We are not inclined to grant extension of time. Unless you agree, Mr. Sharma? You agree to his prayer? No, okay. Heard Mr. Yudathar and counsel for the applicant. Also heard all the respondents are there. Next para. By filing this interlocutory application, the applicant who is the petitioner in the connected WPC 6687 of 2023 has prayed for extension of time as granted by order dated 24/11/2023, passed in WPC 6687 of 2023 for appearing before the Superintendent of Police within bracket border, bracket was Morigaon, and to take bail. In terms of directions contained in the order dated 24/11/2023. Next para. The prayer made in this interlocutory application is opposed by the learned standing counsel for the FT matters. Next para. This court by order dated 24/11/2023 passed in the connected WPC 6687 of 2023, while issuing notice, had granted bail to the petitioner, namely Mohammad Fakharuddin, by providing that he shall appear before the Superintendent of Police within bracket border, bracket was Morigaon, on or before 11/12/2023 during the office hours, and shall furnish a bail bond of rupees 5,000 with one local surety of like amount to the satisfaction of the said authority. Stop. The conditions, the relevant conditions in the said order are quoted below. Page 14, paragraph 9 to 14. 9 to 13. Next paragraph. In order to explain the reasons for not being able to take bail in terms of the said order dated 24/11/2023, the learned counsel for the petitioner has referred to the statements made in paragraph 5 to 9 of this interlocutory application. Full stop. Amongst others, it has been stated by the applicant that on 14/8/2024, his son was also engaged as a laborer at Karur Karur, Karur, in Kerala, met with a unfortunate accident and expired. And accordingly, Peachy, Peechi, Peachy, PS case number 580 oblique 2024 under section 194 of BNSS was registered. Full stop. From the next para, from the narration of events as made in paragraph 5 to 9, it appears that the applicant had been coming to his hometown at his home on several occasions. But his explanation is that that after filing of this writ petition, of the connected writ petition, he got information that work is available as a laborer at Thrissur, THRISSUR, Kerala, and therefore, after filing of the writ petition, he left for the said place. Full stop. His mobile got accidentally damaged, and his SIM card also stopped working, and therefore he could not make communication with his learned counsel. Full stop. Though the applicant came for celebrating Eid in April 2024, but he could not meet his counsel. And thereafter, his counsel could not be met during the BU vacations of this court, and therefore, from filing of the writ petition till 14/8/2024, when his son expired, the petitioner could not, the applicant could not meet his learned counsel. Full stop. The subsequent statement is that the for the events that took place after his son has expired is that the applicant brought his dead son to Morigaon for performing his last rites, and thereafter he left for his work at Thrissur, THRISSUR, in Kerala. And though the applicant came to celebrate Eid in March 2025, but he could not meet his counsel at Guwahati, and therefore he visited his local lawyer, who informed him about the necessity of filing this interlocutory application accordingly. Full stop. Accordingly, this application was filed, has been filed. Next para. It is not the case of the applicant that his learned counsel had not informed the applicant about the order dated 24/11/2023, passed in the connected WBC 6687 of 2023, requiring him to take bail. Full stop. Therefore, the applicant is aware of his requirement to take bail, full stop. Moreover, comma, from the photocopy of the certified copy of the order dated 24/11/2023, comma, annexed to this interlocutory application, comma, it appears that the application for copy was made on 24/11/2023 and the copy was made ready for delivery on 29/11/2023. Full stop, therefore, comma, except for the bereavement period when his son had purportedly, son had allegedly died, comma, all throughout, the applicant had no disability in appearing before the Superintendent of Police to take bail. Full stop. Next paragraph, therefore, comma, the explanation for not being able to appear before the Superintendent of Police, comma, border, within bracket border, comma, Morika, and take bail, or to apply before this court for extension of time are also too vague and bereft of any material particulars to explain the delay. Full stop. Therefore, comma, as this court had made it very clear in paragraph 9 of the order dated 24/11/2023 that the bail has to be taken on or before 11/12/2023, comma, the reason assigned for not being able to take bail by then demonstrates negligence on part of the applicant to comply with the order directions of this court. So therefore, comma, in this case, the petitioner is has willfully disobeyed the order of the court to take bail within 11/12/2023. Full stop. According to comma, we see no reason to extend the time for the applicant to take bail in terms of order dated 24/11/2023. Next, according to this prayer made in this interlocutory application stands dismissed, rejected. So this interlocutory application stands dismissed. In this writ petition, you say, as the both sides are represented, as the LCR is available, comma, list the matter for hearing on, make it Thursday, 17/7/2025.
70. Public.
Item 43 for orders.
Your Lordship, an application praying for extension of this time for offering biometrics, my lord. As per the order dated 29/4/24, page 13, my lord.
Where is the order?
Page 13, my lord.
13. You were to appear by when?
My lord.
2018. You were to appear by when? 22/5/24. More than a year.
My lord.
What is your explanation?
My lord, after passing this order, my lord, several times call him, my lord, but not to communicate his, my lord.
Unfortunately, we don't have any mechanism by which our orders can be presented before the litigants. We have no mechanism. You can write to the government to contribute some funds so that the government may allot funds to the High Court, so that every order passed can be communicated. We can go and deliver each to each household who has come to litigation. Some type of contributory fund, you can give it to the government. How do you expect the court to communicate orders to litigants? Please tell us, how do you expect, by what mechanism we will give it? Sorry, as we have no mechanism, we'll have to dismiss it. Because in our order, we can't write that if the lawyer has not communicated, you file cases against him, FIR against the lawyer. We can't say that unless you want to. Once you invite us, then we'll write. Lodge an FIR against the council, have a bar council proceedings drawn up against the council. And for the court, we have no mechanism. Sorry, we are dismissing it. Unless, Mr. Sharma, you again agree. No.
But only biometrics, my lord, if your lordship allow any date, maybe.
2018 matter, Lordship may.
We'll hear the matter.
No, my lord, this order is passed in 24, my lord.
No, whatever we, but 1 year has gone.
My lord gives appear, my lord, and granting bail, my lord.
No, sorry. This order is by my esteemed sister. We have to give respect, full respect to this order. Heard Ms. El Wazida, lead counsel for the applicant. All the respondents are there. Next para. Filing this interlocutory application, comma, the applicant, who is the petitioner in the connected WBC 228 of 2018, is seeking extension of time as granted by this court by order dated 29/4/2024, passed in WPC 228 of 2018 to take bail, comma, which was required to be taken before the Superintendent of Police within bracket border, bracket close Sibsagar, on or before 22/5/2024. Next para, the learned counsel for the applicant has referred to the statements made in paragraph 4 and 5. Has submitted that the said order dated 22/5/2024 could not be brought to the notice of the applicant, comma, who came to know about the order only on 30/5/2025, comma, by which time the date of appearance had expired. Next para. The prayer made in this application is opposed by the learned standing counsel for the FT matters. Next para. There's the court has no mechanism to bring orders passed by this court on 22/5/2024 to bring it to the notice of the applicant. Full stop. Therefore, it was required of the applicant to be vigilant and to know about the orders passed in his writ petition and the requirement to take bail within the specified time. Full stop. Moreover, comma, it is not the case of the applicant that his learned counsel did not apprise him of the order dated 22/5/2024. Full stop. Therefore, comma, if the petitioner is not taken bail within the time specified by order dated 29/4/2024, comma, court finds no ground to grant extension of time to the applicant to take bail in terms of order which was passed a year back. Accordingly, the pair made in this application stands rejected, and this interlocutory application stands dismissed. And the connected writ petition is say all sides are represented as the records are available, comma, issue rule returnable forthwith without requiring any fresh steps to be taken, or rule is already issued. Then you say, as the records of the tribunal is received, comma, list the matter for hearing on Friday, Tuesday, Thursday, Tuesday. Tuesday. Okay. List the matter for hearing on 22/7/2025.
Item 44, 45, 46 for hearing.
Issue rule is not there.
And I file an additional affidavit, right? Yes, here, ma'am. Flag mark F, my lord.
All sides have 3 minutes time to conclude your argument.
Well, possibly 44, your lordship can decide.
Madam, this is another date may fix, madam.
Possibly 44, your lordship can decide by 3 minutes. Because the other day, your lordship had already expressed mind to my friend. That
No, I don't know. I don't have mind to remember that.
Okay.
So may I
It's a writ appeal, my lord, filed against a composite order passed under 226 and 227 jurisdiction. The previous.
I remember now.
Jurisdiction bench, my lord, had formed an opinion that basically it's an order under 227 jurisdiction and therefore writ appeal will not be made to the board. So that order is there for 4th of February, your lordship may see.
Okay, because we have to rise at 3:20. We list the matter on Thursday.
Thursday, my lord.
Thursday, 17th.
17.
All parties are represented. Due to positive time, the matter cannot be taken up today. List on 17/7/2025.
17.
We don't have 70.
I also have time to learn this.
Unless bar takes a resolution. Yes.
The application, Your lordship. Petitioner number 1 was arrested on 22/7/22, that is 2 year, 11 months, 18 days as of today, your lordship. And the petitioner number 2
Just a moment. Okay, we give you notice. Next week we'll take it up.
Your
Uh,
Lordship, there's another case, is the co-accused has filed an VA, Your Lordship. That case, this case may be tagged with that VA, Your Lordship.
No, we are not
This
giving the tagging order because of the fact that
This second bail application.
because this has come to this bench because of the previous order.
Yes.
So the last orders who have passed, we don't know. Let the registry do the tagging. We will not do the tagging. We have some logistic difficulties in tagging the matters. Because this is not a regular bail bench.
Yes. The scan copy has been called in that case, Your Lordship. The scan copy has been called in that case, Your Lordship.
It's okay. When is that matter fixed?
Lower court matter, Your Lordship.
No, the other bail application.
To online viewing, Your Lordship, 6/5/25 was the last date, Your Lordship. Since then, it's not been listed, Your Lordship.
Okay. Miss S. Nazneen,
Nazneen.
NAZNWN, and counsel for the applicant, for the petitioner, submits that the scanned copy of the relevant records has been called for in connection with another bail application being
BA number
BA number
570/25.
2025. Next paragraph. Let me just check when is the next date fixed bail application BA 570/2025. You don't need copy of the order. Just check it when is the next date.
Five 570. After
Which date?
6/5.
No. 6/5/2025. Next paragraph. In the meantime, issue notice of this application to the state through the London APP. Next paragraph, this time we Goswami London APP access notice on behalf of the state. Next paragraph. Does this matter on Friday? Friday is 18/7/2025. So next paragraph, in the event the scan copy of the records is available in BA 570 of 2025, let that record be tagged when this application is listed. Next paragraph, it is clarified that the records are being tagged only for the purpose of perusal of the scanned copy of records and not for taking up hearing of that matter. That's published on 18/7/2025.
Item 2.
Item 2.
Deeply obliged.
Right, please, Your Lordship. My lord, this is charge sheeted case, my lord. And my lord, charge sheet has been submitted, my lord, on 30/9/2024.
Why this has come before this bench?
My lord, that earlier, my lord, this petition was withdrawn.
Did I pass
The
any
letter
orders
was
there? No.
listed before your lordship.
No, no. Did I pass any bail order accepting or rejecting it? No.
No, my lord.
No, then this has to
Only
go to the regular bench.
Only.
Mr. S. A. Ahmed, learned counsel for the petitioners, as well as Mr. MP Goswami and APPs are present. Next para. The earlier bail application of the petitioners being AB 1478 of 2025 was closed on withdrawal with liberty to approach the court again. First of therefore, comma. This is not a case where this bench had either passed or rejected any previous bail application of the petitioner on merit. Next para. Accordingly, the registry shall list the matter before the appropriate bench. Because this order should be brought to the notice of AOJ
Criminal appeal section.
Criminal Appeal Section. Okay. AOJ. ইহঁতে চাব আপুনি কৈ দিলে হ'ল হা আপুনি কৈ দিলে হ'ল don't like that. This will be the appropriate bench.
Lord, my lord, may I pray for a date, my lord? A direction to fix the matter, my lord. Fix
Pardon
the
me?
date.
It will come. Let them coordinate. Because if I give a date, it has to be routed through the registry and then it
Fine.
comes.
Oblige.
If it does not come, make a mention day after tomorrow before the appropriate bench.
Oblige.